Hi, I'm Scott Brown of Scott Brown and Associates. I'm board certified in divorce and family law. Today we're going to talk about child support. Often I have clients ask, what can they do if they're not receiving enough money to meet their child's needs? How can they get it increased? So that's the topic we're going to discuss today. Even though your divorce decree says final, the court retains the power to increase or decrease the amount of child support you are receiving. There are two avenues for obtaining an increase in child support. You and your children's other parent can agree to the increase, or you can petition the court and prove your need for an increase at a hearing. Let's look at each of these options. First, negotiating an increase by agreement. If you are on good terms with your children's other parent, the two of you may be able to reach an agreement. If direct negotiations are too difficult, your attorneys can negotiate on your behalf. Mediation is a third option for reaching an agreement. Any agreement you reach must be presented to the court for incorporation into a court order. A child support modification is not enforceable until the court orders it. An agreement offers several benefits. An agreement will save you money on court and attorney's fees, reduce the risk of an unfavorable outcome, and preserve a civil relationship with your child's other parent. If negotiation and mediation are not successful, you can still petition the court for an increase in child support. So secondly, let's look at going to court. You will need to file a petition for an increase in child support, serve it on the other parent, and schedule a court hearing. At the hearing, most courts will require you to prove a substantial change of circumstances has occurred. You must show that something has happened since the court made the last support order, and you now need an increase in support to meet your children's needs. Depending on the type of changed circumstances you allege, the court can modify the court order temporarily or permanently. Changed circumstances that could justify an increase in child support include the paying parent gets a raise or finds a better job, the children's needs increase as they get older, a child needs specialized medical care or educational support, inflation has eroded the purchasing power of a dated support order, the children are spending more overnights with you and you need more child support to cover the additional expense. These are just some examples. There are many more examples that could modify a child support order. Now, success in court is never guaranteed. Your children's other parent may oppose your petition or even request a child support reduction. You may be unaware that his or her circumstances have changed for the worse. For example, because of an income reduction, disability, birth of another child, a job loss, a layoff. Any of those things could also make the child support come down for the other parent. Now, how often can you seek a child support modification? In Texas, the Texas Family Code says that first, the circumstances of the child or a person affected by the order have materially and substantially changed since the earlier of the date of the court order's rendition or the date of the signing of a mediated settlement agreement, or it has been 3 years since the order was rendered or last modified, and the monthly amount of the child support award under the order differs by either 20% or $100 from the amount that would be awarded in accordance with the child support guidelines. The restrictions discourage frequent petitions that increase the court's workload but result in little or no change in the support amount. How can you know if the other parent's circumstances have changed? Parents need to keep up with any change in circumstances that could warrant a child support modification. One way to do this is to agree to exchange financial affidavits or declarations together with pay stubs and tax returns with the other parent at least annually. You may discover that the guideline child support changes little from the initial order and it is not worth the time and money it will take to seek a modification. If the amount changes considerably, you will have the information to negotiate an increase with the other parent or proceed to court. Many courts have a child support services department that provides free help calculating child support. Other courts may provide a child support calculator on their websites. Your family law attorney can also help you estimate the guideline child support before you decide whether to take the next steps. We are available to discuss your situation. If you would like to discuss the issue of child support in more detail, please give us a call here at Scott Brown and Associates.